This is the contract review for the as-is contract, new 2021 version. So if you have been through my presentation that talks about the changes in the contract, I will be incorporating those changes into the new presentation. So I'm going to focus on some of the changes today as well, but I'm going to be going through the entire contract. And if you have a question that is not relevant to the section that I'm on, just wait to see if I cover that section. Odds are I might, or wait until the end to ask the question. And of course, you could always put questions in the chat as well. I will be monitoring that. Okay, so we're going to get started now. For those of you who are just finding out about us new, we are JK Closing Attorneys. We are a real estate law firm. We are not a title company. So we are a law firm with multiple attorneys. I'm the managing attorney and owner of the company. And we do all of the same things that title companies do, but we also represent buyers and sellers. So we could do seller representations in Broward and Miami, and we could do buyer representations in Palm Beach County and elsewhere where the seller pays for title. Okay. And hang on a second, because you guys are not seeing my screen change. Why not? Okay, now you can see it. Okay, so first page of the as-is contract. In the upper left-hand corner, it starts with as is. If you are a listing agent and you receive an offer that does not say as is in the upper left, you need to go back to that buyer's agent and say, please submit your contract on the as-is contract. There is a standard real estate contract also put out by the Florida Bar and Florida Realtors that is not as is. And the major difference between that contract and this contract is that in the as-is contract, the buyer has an inspection period and they can just terminate for whatever reason they want or no reason at all. Under the standard contract, the seller must repair the property based on the inspection report up to a certain dollar amount. So that is drastically different than what all of us are used to in real estate, residential real estate transactions. So please be mindful of that. If you get a contract and you just think that it looks a little bit weird, it's probably because it's the standard contract. Buyer's agents will typically submit an offer on that contract by mistake, or if there's an attorney working for the buyer, they might be doing it on purpose in order to lock in the seller to have to make repairs to the property. So just be aware, that's the first thing you should look at, as is, top left corner, make sure it's the as is contract. Also, I mentioned earlier, this is the new contract. It says down at the bottom, revised 10/21/2021. If you are receiving an offer on a 2019 contract, or a 2017 contract, it will not have the new updates on it. From the seller side, this 2021 contract is much better. So if you are a listing agent, don't accept an old contract. From the buyer side, it's not detrimental to use an old contract, but there are specific changes that have been made that you would have to be aware of, which we will cover a little bit later. Rule of thumb is to use the most recent contract, though. That's what everybody is familiar with. Okay. Top two lines, seller and buyer. I've written in here, do not write owner of record. If you're submitting an offer, don't rely on the listing agent to tell you who the owner of the property is. Do your research. Look at the property tax records. However, don't just use the name that's on BCPA or PAPA or whatever they call Miami's. That tax record might just be the person who paid for taxes last, or it might be incomplete. You really need to download the most recent deed and take a look at who the grantees are on that, and make sure that the people who say they own the property are actually the ones who are on the deed. From the listing agent perspective, before you sign a listing agreement, you need to make sure that the person you're dealing with is actually the owner of the property. So if you're dealing with John Smith the entire time and he's signing your listing agreement, and you look at the previous deed and it says Kate Smith, you need to figure out who Kate is. Is Kate mom? Is Kate John's wife? Is Kate dead? We don't know. So if you have the wrong person signing your listing agreement is invalid. You won't have the right to put the property on the MLS, and any contract that John Smith signs might be invalid. The property could need to be probated. Let's say if Kate Smith is dead, John Smith might have the right to sell the property, but not until it goes through probate. So again, to protect yourselves and to not be spinning your wheels and wasting time on a listing or an offer, you need to make sure that you have the right seller. Similarly, if it's an LLC that owns, you want to make sure that the right people are signing the contract. So LLC or corporation, you want to make sure either the president or the managers or the members, whoever is listed on Sunbiz, I would have them sign the contract, especially if it's an LLC. For a corporation, you can have the president sign. If you're a listing agent and you have a company that's the seller, you want to make sure that the person who's signing has the authority to sell the property. So if it's a corporation, you need a resolution from the board members giving the authority to the president to sell the property. If it's an LLC and you have multiple members, have multiple members sign the listing agreement. Okay, if you guys have any questions about that type of stuff, you can always reach out to us. I can take a look at Sunbiz. I can take a look at the deeds for you. That's what I do all day long. So if you have a deed that you're not sure of, take a screenshot of it, text it to me. I can let you know. If I'm still not sure about it, then I'll look at all the deeds that are listed and I'll try to give you a better idea. If we're still not sure who the owner is, we'll run a title search. Okay, so that's what we're here for. Okay, jumping down to section 1. Section 1, personal property section. I've highlighted thermostats, doorbells, television wall mounts. Those are new additions in addition to storm shutters and storm protection items and mailbox keys. The biggest takeaway for personal property is you want to make sure that the seller and the buyer are on the same page as to who's getting what at closing. This section is the section most likely to cause an issue at walkthrough. Okay, I've written in here washer, dryer, and microwave. If the buyer goes to walkthrough and there is no washer and dryer at the walkthrough, I'm going to get a call, or you're going to get a call if you're the listing agent or if I'm the closing agent, and there's going to be a dispute. The first thing I'm going to do is go back to the contract and figure out whether or not washer or dryer was written there. Because if it's not, the buyer is not entitled to the washer and dryer. And it doesn't matter what's on the MLS. If the MLS says the property is being sold with all of the things in the pictures, if that's not written down in this section of the contract, it doesn't matter, because the MLS is not a contract between the buyer and the seller. This is. I've seen some people write as per MLS in this line. If you're going to do that, then screenshot the MLS and attach it with the offer and the contract, because the MLS can change. Okay, and I've had that happen before too. I've had listing agents change the MLS to either change commission rates or change the items that were being sold with the property, or change the broker's remarks for the disclosures that they were making. So from the buyer's standpoint and the buyer's agent, you need to make sure that you screenshot that MLS before you make an offer, because you don't want to make an offer and then all of a sudden you find out that it's 2.5% and you thought it was 3%. You might be right that it was a 3% commission, and it could have changed as soon as you submitted the offer. So screenshot your MLSs, save that, okay? Thermostats, doorbells, and TV wall mounts. They've added these in. sellers are spending thousands of dollars on smart thermostats, smart doorbells, and they also have wall-mounted TVs. From the listing perspective, if you see that your client has all of these items in there, you need to check with them to see if they're taking them with them. Some of these people have subscription services for their doorbells, and they think that they're just going to take it and bring it to their new house. If they are going to do that, you need to cross these items off from this section and write them in the excluded section, E. Okay, so everything in D is included in the property. Everything in E is excluded. Okay. If section D doesn't have thermostats or doorbells crossed out, but you write thermostats and doorbells here, I would argue that that's conflicting language. So I would want it crossed out in the personal property section and also added to the excluded section. Okay. Every other item that's on here, if it doesn't exist, the seller is not responsible for buying it and giving it to the buyer. Okay, so if there are no draperies, blinds, window treatments, it doesn't mean that the seller has to go buy them. Okay, I've had buyers argue that before, which is always fun. But no, the seller does not have to do it. It's only if they exist. Because it says which are owned by seller and existing on the property as of the date of the initial offer. Okay. Does anybody have any questions about the personal property section before we move on? Again, we want to take care of this section prior to entering into contract because you don't want to deal with an issue at the walkthrough when a buyer says that they're not getting what they contracted for and the seller is not going to give in the day before closing. Guess who's going to have to pay for it? You guys. I've seen too many agents have to give up partial commission in order to pay for stupid $100, $200 items that they didn't take care of prior to entering into contract. Make sure everybody's on the same page. Okay, purchase price section. I have outlined collected funds C standard S. When you see something in the contract that says C standard, there are different definitions for things in the back of the contract, section 18. They're called standards. The definition of collected is in the back of the contract in standard S. What does collected mean? Collected means that the funds have to be in my bank account. So if I'm the closing agent or the escrow agent and the buyer makes a deposit, that deposit is not collected until I put it into my bank account. So this is why escrow agents give escrow letters. They are telling everybody, hey, we've got the check and we deposited it. Great. We might have some CYA language on there that says if it's a personal check, give it up to 7 business days to clear or something like that. But for all intents and purposes, we've collected it. If you guys as buyer's agents or listing agents receive a check and you do not give it to the escrow agent to deposit, it is not collected and the buyer could end up in default. And you guys could end up getting sued by the buyer. So do not hang on to checks for a week. Come drop them off at our office, or if you can't get to our office, just call us up and we'll send somebody to you to get it. Okay, that's something that we're here for. We've had this happen a lot in this market where buyers have not made the deposit on time and the listing agent will call me and ask if the seller can get out of the contract. Technically, per the terms of this contract, not making the deposit on time is a default from the buyer side, and the seller is not obligated to move forward with anything on the contract if the buyer is in default. So make sure that your buyers are making their deposits timely. Also, just a PSA, sometimes people in my office, usually the processors or the opening team, will get emails from agents asking for an escrow letter. And then we will have an internal discussion in my office because we have not received the escrow yet. So please be patient with my office. And if we have not received an escrow from the buyer side, we may be reaching out to the buyer to make sure that we get that escrow. Maybe it was missed. Maybe they didn't send the wire right away. Maybe they sent it ACH. Okay, you cannot send an ACH payment to our bank account. It'll get rejected. Okay, so please just give us a call if you think something should have been deposited and we're not giving you an escrow letter yet. On the financing section, line 39, I wrote use percentage. Do not put a dollar amount there, because if you put a dollar amount there and the purchase price ends up changing, the buyer could end up being in default for not applying for the correct loan amount. And so, for instance, if you're applying for an 80% loan to value and the purchase price is $500,000, so the buyer is applying for a loan that's $400,000. If the purchase price changes to $510,000 and 80% is written here, it's not a big deal. But if 400,000 was written here, then the buyer's no longer applying for an 80% loan to value if the purchase price changes to 510,000. So if the lender's working on 80% loan to value, and that's what the buyer's applying for, and 400,000 is written here, and the purchase price is 510, the buyer is never actually applying for a loan that they said they were going to apply for as per the terms of the contract. That's a default, technically. And there's a court case about that too, where the buyer was held in default, even though they backed out during their loan approval period, because the seller found out that they didn't apply for a loan as per the terms of the contract. So you have to be careful with those things. Time for acceptance of offer and counter offers and effective date. 3A talks about the time for acceptance and offers and counter offers. And it says, if not signed by buyer and seller and an executed copy delivered to all parties on or before blank, this offer shall be deemed withdrawn. Okay, so today is March 29th. If we have March 29th written in here and the buyer makes an offer and the seller does not sign it and accept it or counter offer today, and keyword deliver it back to the buyer, then the offer is withdrawn. Okay, which means that there's no contract. So if the seller signs this or they counter offer and they don't send it back until tomorrow, there is no, it's not considered an effective contract and it's not considered an effective counter offer because the offer has been deemed withdrawn. So what is that when the seller sends it back tomorrow? That's just an offer from the seller to the buyer on the seller's terms, okay? And then the buyer would need to cross off the time for acceptance, change the date, reinitial it, and then also initial any of the changes that the seller has made. So be careful of that. In this market, buyers, sellers have many, many offers. You may want to give them a couple of days to respond, or you might want to leave this blank. If you leave it blank, no harm, no foul from the buyer side, as long as you have an inspection period. And I say that because if you submit an offer that has no time for acceptance on it, the seller can sign it and return it to you whenever they want. So let's say a month from now, the seller's first offer falls through, and then they go back to your contract and they realize there's no time for acceptance on it. They could just sign it and send it back to you. That's okay from the buyer side if you have an inspection period, because you could just cancel this contract if you have an inspection period. But in this market, there are some contracts being offered without any inspection period. So you have to be careful as to your time for acceptance, because you don't want to leave it open-ended and then find out in a month that the buyer has accepted your offer. Question from Nancy, do the sellers have to initial the date change? Yes, any changes, any crossouts that are in the contract generally need to be initialed by both parties anyway. So if 329 is written here and the seller is not going to return it back until tomorrow, the seller needs to cross off 329 and write 330 or 331 and initial it. And then the buyer, in order to make the contract effective, will also need to initial that date change too. And then initial any of the other changes that the seller has made on their counteroffer. Okay, The second part of this says, unless otherwise stated, time for acceptance of any counter offers shall be within 2 days after the day the counter offer is delivered. What does that mean? If the seller gives the buyer a counter offer, the buyer has 2 days to respond to that counter offer. So let's pretend again, this says 329 here. The seller submits their counter offer back to the buyer 329. Okay. Today is Tuesday. What day does the buyer have to respond to the counter offer by? Does anybody know?
Thursday, right?
Thursday, correct, Patty. That would be 2 days from Tuesday. So Tuesday would count as day 0, Wednesday would count as day 1, and Thursday would be day 2. Okay, and it's not Thursday at 5 p.m. or whenever the seller made the counter offer. It's till the end of the day because it's days, not hours. Okay, and we'll go over counting days more in a minute. Question from Rob: what if the buyer doesn't initial the date change but still makes a deposit? There's still no contract because their initial offer was withdrawn. Now, lawyers will argue later on, let's say everybody's following the terms of the contract for a month and everyone's operating as if the contract is effective. There might be evidence that the contract is effective. And if they sued each other, the buyer and the seller might find out from the judge that it's effective. But we don't want to take that chance because that's not what the contract says. And everything in a real estate contract has to be written. And so when a contract has been withdrawn and we've been operating like it's in effect, that would be considered an oral contract. So we don't want to make that mistake. It's very, very important. And just coming from an attorney who represents sellers, if a seller wants to get out of a contract, one of the first things I do is figure out whether or not the offer was actually accepted during the right time period, because that's one of the easiest ways for me to say that the seller never had an executed contract. And there are other attorneys that will do that as well. Part 3B, the effective date of this contract shall be the date when the last one of the buyer and seller has signed or initialed and delivered this offer or final counter offer. Notice how there's no blank space here. You can't just write in the effective date of the contract. It's when the last party has initialed, signed, and delivered it to the other party. Okay, so if buyer receives an offer today, if seller receives an offer today, and then they sign it and send it back to the buyer, the effective date is today because they signed, initialed, and delivered it to the buyer today. If the contract is sent over to the seller and it is 11:30 at night and the seller signs it and the listing agent doesn't send it over to the buyer until tomorrow, the effective date is tomorrow. But my office is never going to know that the effective date is actually 3:30 unless the agents tell us, because all of the signatures, if they are time-stamped, and all of the initials, if they're time-stamped, are going to show 3/29 as the date that it's signed. So if you have a situation like that, you need to make sure that the closing agent knows that, hey, this actually wasn't delivered until the next day. So if you guys are having your client sign in App Files or one of those programs, and it's only sent back to you and not sent to both parties, once you email it over to the buyer's agent, that's when it's delivered. Okay, if you have an elderly client that is still signing in hand, okay, they might be signing in person, wet ink, and then you're holding on to the contract. The contract is not effective until you hand deliver it to the buyer or buyer's agent, or you scan it in and email it to the buyer's agent. So you could be hanging on to that contract for a day or two. All of the dates could be 2 days previous, and it's actually not effective for a couple of days. That's something that we all need to know about, because the effective date is probably the most important date of the contract, because all of the timelines will then be determined based off of the effective date. Okay. I mentioned before that in the back of the contract, standards have all these definitions. We're going to go over one of those definitions right now. The definition of time. In this contract, time is of the essence. And hold on, I have a question first that I'm going to answer before I get into this. Suppose today is the last day of the time and acceptance. Seller counters the offer. Buyer has until Thursday to accept the counter, but time of acceptance expired on Tuesday. Does the time of acceptance need to change? No. So if the time of acceptance is today and the seller counter offers, now we are using the 2-day time period. The buyer has 2 days to respond to that counter offer. You do not need to change the time for acceptance. And then if the buyer counter offers again on Thursday, then the seller has through Saturday to respond to that. You do not need to change the time for acceptance. And hopefully you guys are emailing these back and forth, because we'll be able to track them based on the date. Okay. So standard F for time. Time is of the essence in this contract. This is in bold and I highlighted it. Time is of the essence is a legal term of art that's been around for hundreds of years in English common law. It means that every deadline in the contract is a hard deadline. Your inspection period is 7 days. It ends after the 7th day. Your loan approval period is 21 days. It ends. There's no leeway. If you go to court and you argue that the buyer submitted an addendum to the seller and the seller didn't sign it during the inspection period, the judge is going to say, well, your inspection period ended. So what do you want me to do? Because time is of the essence in this contract and you didn't cancel the contract. Okay. If you guys have clients who are international, they don't deal with English common law. Maybe they're on French civil code, or maybe they're in a country that has a monarch and all of their laws generate from the king. Maybe they're in a country that's more used to handshake deals, not contracts. They are not used to a term like time is of the essence. They think that timelines can come and go and don't worry, we'll come to an agreement. Everybody's on the same page. It's not a big deal. They need to understand that it is a big deal. If you have a lender that you're working with that's like that, the loan approval period is the loan approval period. You can't find out on day 20 that they don't have loan approval and the loan approval period ends on day 21 and the lender's like, oh, it's not a big deal. It is a big deal. The buyer either needs to cancel the contract or they need to get an extension. So the next part of standard F talks about how to count days. Calendar days are to be used in this contract. Okay, it does not say business day anywhere in this contract. Okay, other than time for acceptance and effective date, any time periods provided for or dates specified in this contract, whether pre-printed, handwritten, typewritten, or inserted herein, which shall end or occur on a Saturday, Sunday, or national legal public holiday, or a day on which a national legal public holiday is observed because it fell on a Saturday or Sunday, shall extend to the next calendar day, which is not a Saturday, Sunday, or national public holiday, or a day on which a national legal public holiday is observed. Okay, let's unpack that. First part, other than time for acceptance and effective date. This means that everything that follows here does not apply to time for acceptance and effective date. You can have the time for acceptance and the effective date on a weekend. You can have it on a holiday. People sign contracts on weekends and holidays. Okay, the effective date can be on Easter. That's fine. That's just day 0. That's when all of the timelines start. Okay, what you can't have though is a closing date that's on Easter. You can't have an inspection period that ends on a weekend or a holiday. You can't have a loan approval period that ends on a weekend or holiday. If any of the other timelines in this contract fall on a weekend or a holiday, then it will be extended to the next day, which is not a weekend or a holiday. Okay, and we don't use the term business day because lenders include Saturdays as business days. Banks are open on Saturdays. We can't send wires, so we can't do a closing on a Saturday. But in some industries, Saturdays are considered a business day, which is why this contract no longer says business day. Okay, so we're going to go through an example. Here's standard F, and below standard F here is our example. If the effective date of the contract is Wednesday, November 23rd, 2022, and the time period for making the deposit is within 3 days after the effective date, the deposit must be made no later than Monday, November 28th. Why is that? That's 5 days. So how is it 5 days if it's supposed to be within 3 days? Wednesday, the effective date, would not be counted. The effective date is never counted. It's always day 0. Okay. Thursday, Thanksgiving. Do we count Thursday, Thanksgiving as day 1? The answer is yes, we do count Thursday, but it's a holiday. We just read that whole section that said that we can't count holidays. That's only if the deadline ends on a holiday. If a holiday is in the middle of a time period, you count it because we use calendar days. So Thursday, Thanksgiving, ends up being day 1. Friday, Black Friday, day 2, also not a holiday. Our office is closed on Black Friday, just FYI. Saturday would normally be day 3, but we don't count it because a deadline cannot end on a Saturday or a holiday. So we go to the next day, Sunday, also a weekend. We don't count it. The next possible day that the deposit can be due is Monday, November 28th. That would be day 3. Okay. Does anybody have any questions about that? You may think that it is stupid if you have a question about counting days, because I know that you guys tell me that. You say, hey, this is a stupid question. There are no stupid questions, but if you have a question about the effective date, about counting time periods, the sooner you resolve it in the contract, the better, because you want to get everybody on the same page. The contingency deadlines in the contract are the most important thing that we have to deal with throughout the contract. And if we miss one, your buyer's deposit is going to be in jeopardy. Okay, so we need to be on the same page as you. When we open up a file, we send out a welcome letter that has the contingencies in it. If our deadlines don't match up with your deadlines, give us a call or give us an email. Maybe you have information that we don't have. Maybe we made a mistake. Maybe you made a mistake. It happens, but it's important to be on the same page with everybody. If there's a legitimate dispute over what day the effective date is, my recommendation is always to create an addendum and have the parties agree as to what the effective date is. And that's it. Then you know what all your timelines are from there on out. Okay, page 2 of the contract. Don't worry, I'm not going to go through all the pages of the contract and spend that much time on them, but I'm going to cover the important parts. Closing date has been moved to page 2. I have seen people on the new contract leave the closing date blank because they miss it at the top of the second page. Do not miss the closing date, because if you do, the contract is not effective until there's a closing date in there. If you have a new construction and you're using the as-is contract for it, sometimes people modify the as-is contract and do that. You cannot write in here simply X amount of days after the certificate of occupancy has been acquired, because if the seller and the builder do not get the certificate of occupancy ever, then the buyer is just locked into this contract until they get the certificate of occupancy, or they might have to sue the seller for non-performance or something like that. So you need to make sure that there are clear deadlines. Also, tip, do not pick the 15th or the end of the month. Everybody picks the 15th and the end of the month. If you want higher priority on your files, every closing agent, not just my office, you guys are all inundated. The title companies are all inundated. If everybody's trying to close at the end of the month, there's less time for each file to be considered. So rule of thumb, don't put the end of the month. Best days to close, Tuesday, Wednesday, or Thursday. Okay. Because if there's an issue, we can end up pushing it towards the end of the week if we need to. If you have a closing date that's on a Monday, generally everything has to be done by Friday to close Monday, especially if there's financing involved. Okay, so just be aware of that. We have title companies that we've dealt with that have told us we are too busy to close today. Now, you guys won't hear that from us, but we've heard it. So I don't want you guys to be in that position with your clients where everybody is ready to close and then someone that is not you guys is not able to close because your clients are going to be upset. Okay. When we do seller representations and sellers on title files, we generally have them signed before the closing date. So if you're a listing agent, prepare your client to say, hey, don't worry about when you have to sign. We're going to schedule it with the closing company so that you don't have to show up on closing. Not every company does that, by the way, but they should. So extension of the closing date, section 5. This 5A is the TRID section. You may have heard it called that. Okay, it deals with CFPB requirements. CFPB, Consumer Financial Protection Bureau, is a federal organization that regulates lenders and real estate transactions. If your lender is saying, we need to extend the closing date because we did not disclose the closing disclosure, they are entitled to extend the closing date because of this section. Okay. CFPB says that lenders have to give a CD out at least 3 days prior to closing. However, the new contract says in order for them to take advantage of this section, loan approval must have been obtained and lender's underwriting must be complete. So from the seller side, if I'm representing a seller, if the lender is saying, I need to extend the closing date because I didn't disclose the CD, then I'm asking for loan approval. I want in writing that it's been obtained, and I want in writing that underwriting is complete. Because if it's not, then they are not entitled to get that extension. Similarly, from the buyer side, make sure you are on the same page with your lenders. If your lender is not disclosing the CD early in the transaction, I don't know what they're doing. They do not have to wait for underwriting to be complete to disclose a CD. They just don't. We have lenders that disclose a CD very early on in the transaction. So if your lender is not doing that, or your buyer's lender is not doing that, you need to check with them why. Sometimes we have lenders that disclose the CD and there's a mistake on it, and then they have to redisclose later. That's often a situation in which we have to extend the closing date for this section. But we also have lenders that just think they can extend the closing date and use this section as an excuse when they're not entitled to it. So especially when I'm on the seller side, I'm going to give pushback on that because I want to protect the seller's interests. Okay. We'll come back to this section and talk about it when we talk about the financing section. Section 6B. If the property is subject to lease or occupancy after closing, either from a tenant or a seller, this box should be checked. I have put a box around Rider U, which is the post-closing occupancy addendum. We do not like Rider U. I'm going to give you language later that is in place of Rider U, but the post-occupancy language that's on Rider U is not adequate. And the rider also gives the buyer, it makes the contract contingent on agreeing to a post-occupancy agreement. So the buyer and the seller actually have the opportunity to cancel the contract if they don't agree on the post-occupancy agreement. So that's why I don't like Rider U. By the way, I'm going to post this, and I'm going to post some of the materials from this in our Facebook group afterwards. So if you guys want to get some of the documents that I'm going to be talking about in here, that's where it's going to be. Financing section. This contract has significant changes to the financing section from the previous contract, okay? Section 8A says this is a cash transaction with no financing contingency. They removed a bunch of filler language that was in here, doesn't actually change what this means. The buyer can still get financing if this box is checked. They can get their money from anywhere. It just means they have no contingency. So if they get denied for a loan, they can't cancel the contract because they don't have loan approval. That's what this means. Okay. If you have this box checked, the buyer is still entitled to get an appraisal, and they're still entitled to enter the property for inspection and all sorts of things like that. It says that in standard L of the contract. Okay. If we want to remove their ability to do that, we need to change the additional terms. Okay. 8B. This contract is contingent upon within blank days after the effective date. 1, buyer obtaining approval of a loan, conventional FHA, VA. It has their rate. If you leave everything blank, it's going to be prevailing rate. If you leave this blank, it's going to be a term of 30 years, which is standard. Okay. This is the first component of the loan approval definition in the new contract. The second part is the appraisal. If buyer's mortgage broker or lender, having received an appraisal or alternative valuation of the property satisfactory to lender, if either is required by lender, which is sufficient to meet the terms required for lender to provide financing for buyer and to proceed to closing. What does that mean? It means that if the buyer's loan approval is conditioned on appraisal, then the buyer cannot get loan approval without having that appraisal. So if the lender needs an appraisal, the buyer cannot get loan approval until we have that appraisal done. So all of the appraisals need to be done during the loan approval period. Otherwise, the buyer just can't get loan approval per the terms of this contract. Doesn't mean they can't close. They can get the appraisal after the loan approval period's over. It just means that they're not going to be able to close. That is one of the bigger changes in this contract, and it changes what lenders have been doing previously. So we have a lot of lenders that are doing very short loan approval periods and then getting the appraisal after that loan approval period, because in the old contract, there was an appraisal contingency that allowed the buyer to back out of the contract. Okay, so that doesn't exist anymore. So either the appraisal gets done during the loan approval period, and if it's the loan approval is conditioned on appraisal and it doesn't appraise, the buyer can terminate during their loan approval period. So this is leading to buyers submitting offers with longer loan approval periods. But also we have offers where buyers are waiving the appraisal. We're going to talk about that in a little while. There's not an easy way to waive the appraisal in this contract because it's just part of the loan approval. The next section here, you can't really read it because I screwed up with where I put this. But it says, do not promise your clients that they can cancel during the loan approval period and get their deposit back. Why not? Because they have to use good faith and diligent effort in applying for the loan. Okay. Good faith and diligent effort is not defined here. However, it does state that if the buyer does not submit all documents timely to the lender, timely furnishing documents and information required by the mortgage broker or lender, that would be diligent effort. Okay. So I had a situation one time where the buyer's agent told the buyer they were canceling during the loan approval period and that they would get their deposit back. The seller had a savvy attorney and said, okay, send me over your loan denial. The buyer's agent, without consulting anybody, sent over the denial letter, and the denial letter said the buyer was denied for not timely furnishing documents. So the seller said, okay, give me your deposit, you're in default. And they ended up litigating over it. and the buyer lost their deposit. They were in default. But what happened was the buyer ended up suing their agent, and they ended up recovering against their agent because their agent was considered practicing law without a license, because they gave their buyer their interpretation of the contract, which was, you will get your deposit back. And then, because the buyer sent over the denial letter, which is not required, the buyer's agent, the buyer was able to recover from their agent there. The buyers and brokers E&O insurance did not cover this claim against them because the buyer's agent was practicing law without a license. I can't stress this enough, guys. You guys want to give your clients all of the answers, but some of the answers are not within your purview. You do not need to make a decision as to whether or not the buyer will get their deposit back. You may not know all the facts. You may not know all the details. You may not know what the contract says. But that's what we're here for. It's much better to say, you know what, that sounds like a legal question. Let's get the attorney on the line so he can answer it for you. I may give you this exact same answer that you would give to the buyer, but I can do that because I'm licensed to do that. You guys aren't. Okay. So a quick phone call or a text to get an answer could save you guys a lot. So be careful. Not just in this section, but every section in terms of whether or not what you're doing could be construed as legal advice. Line 106, buyer shall, upon written request, keep seller and broker fully informed about the status of buyer's mortgage loan application, loan processing, appraisal, and loan approval, including any property related conditions, okay? Upon written request. If the seller never puts in writing, hey, I need an update on this, the buyer never has to give them one. Okay, so that's number one. Number two, this section does not state that the buyer has to give the seller the appraisal, the loan application, the loan approval. The buyer doesn't have to give those documents to the seller. They just have to keep everybody fully informed about the status. So the status of loan application. Yes, we made the application. No, we did not make the application. Appraisal. Yes, we've gotten the appraisal in. No, we have not gotten the appraisal in. Yes, the property appraised. No, the property didn't appraise. Loan approval. Yes, we have loan approval. No, we haven't gotten loan approval yet. That's it. You do not need to send over the conditional loan approval. This is where buyers get into trouble, especially in this market and under this new contract. I have buyers who are writing in the additional terms that the contract is not contingent on appraisal. So then I ask for their conditional loan approval, and come to find out they have a loan approval that's conditioned on appraisal. Okay, well, can they cancel the contract during the loan approval period or not? They have conflicting language in there. The more information that a seller gets about the buyer's loan approval, the more options they have in terms of pursuing a deposit or claiming that the buyer's in default, and even in negotiating. If you get an appraisal that comes in $50,000 above the sales price and you send it over to the seller, that seller is going to try every which way to get out of the contract and try to get more money. You don't need to send that to the seller. I have a question in the chat here. As an agent, we have the ability to find out from the loan officer what is going on. Yes. So listing agents, feel free to call up the lender. Feel free to ask questions. A chatty lender, lenders love to chat. You guys know that. They will give you more information than they probably should. Buyer's agents, make sure you're on the same page with your lender. Make sure they know. Do not have a conversation with the listing agent unless you are on that call. Do not give out more information than is necessary. Okay? You have to be on the same page with your lender. Your lender, aside from you guys, your lender is the most important person that you're working with on this transaction. My office can close the transaction, but if the lender can't fund it, none of us are closing. So you need to make sure that you're working with a great lender. And a lot of you guys have offices that are working with great lenders. Okay, next section, line 111. If within the loan approval period, buyer obtains loan approval, buyer shall notify seller of the same in writing prior to the expiration of the loan approval period. Or if buyer is unable to obtain loan approval within the loan approval period, but buyer is satisfied with buyer's ability to obtain loan approval and proceed to closing, the buyer shall deliver written notice to the seller confirming the same. And then line 115, if buyer is unable to obtain loan approval with good faith and diligent effort, then the buyer may terminate this contract. Okay, so 3 options. Buyer's got loan approval, we're telling the seller in writing. Or buyer doesn't have loan approval, but they're okay and they're going to move forward anyway. Or number 3, the buyer doesn't have loan approval and they're canceling. Okay, why would the buyer be unable to obtain loan approval, but is okay moving forward? Maybe one of the conditions of their loan approval is the appraisal, and they have an appraisal contingency. That would be a situation where they would say, hey, I don't have loan approval yet, but we're just waiting on the appraisal. I have an appraisal contingency, so if it comes in super low, I can cancel. So at the end of the loan approval period, they can put in writing, I don't have loan approval, but I'm moving forward. Okay, that would be a scenario like that. Line 120. What happens if we don't put any of these options in writing? If buyer fails to timely deliver any written notice prior to the expiration of the loan approval period, then the buyer shall proceed forward with this contract as though paragraph 8A has been checked. Does everybody remember what 8A is? Cash. So if you are representing the buyer and your loan approval period comes and goes and you say nothing, the deal is now cash. Also, it says seller may elect to terminate this contract. So if you're silent, here are your ramifications. Cash transaction or seller can cancel. Either way, your buyer's not going to be happy. What are the ramifications of having a cash transaction? Well, if we go up to section 5A again, if we remember the TRID clause, this section only applies if paragraph 8B is checked. So if we're reverting to a cash transaction now and the lender, everything's going smoothly on your transaction. The lender says, hey, we need 3 extra days because we didn't disclose the CD. A savvy seller's attorney is going to figure out whether or not you put in writing that you have loan approval. And if you didn't, they're going to say, sorry, this is a cash transaction. You don't get access to this section. Or let's say you have a condo. And most of us know that the Fannie and Freddie guidelines have changed for condos. There is more that the buyer needs to show to get loan approval in terms of property related conditions. This section says if the buyer has timely provided written notice above and fails to close, then the deposit will be paid to the seller unless the fail to close is due to seller's default or property related conditions of the loan approval have not been met. So if you go past the loan approval period and you're silent, the buyer does not have access to this section. And you have no control over whether or not there are property related conditions. So I've had this happen to buyers already. I've had it happen where buyers have timely submitted their written, whether they said they have loan approval or they're moving forward. And I've had buyers who have not done that. Every time, no matter what, if there's a property related condition or a TRID extension, there's a dispute. There's an argument over whether or not the contract allows them to do that. It just ends up in dispute. So you want to make sure that your I's are dotted and your T's are crossed. If you are silent, you are putting your buyer's deposit in jeopardy, and you are also putting yourself at risk for getting sued. So what is the solution to this? We have a document that we've been giving to agents that have asked for it. and it has all three options on here. The buyer has obtained loan approval and is moving forward. Buyer is initialing that. Buyer has not obtained loan approval, but is moving forward. Or buyer has not obtained loan approval and is terminating the contract. We want the buyer to initial this because we don't want the buyer to later come back to you and say, hey, you told us I had loan approval and we're moving forward, or you told the seller that, and now my lender pulled my loan approval. Who are they going to go after? They're going to go after you because they always blame you for everything. If you have this in writing, you're protecting yourself. Okay, protect your license. This also forces everybody to have a conversation with the lender. Is it okay to say we have loan approval? From the buyer side, I want you guys asking the lender if it's okay to tell the seller you have loan approval. So when they send out a conditional loan approval, and every loan approval is conditional, when they send that out, can you really tell the seller that you have loan approval? Get it in writing from the lender that it's okay to do that. Rule of thumb for me with conditional loan approval is if the buyer can satisfy all of the conditions that are on that loan approval, then they have loan approval. If there's something on, if one of those conditions on the loan approval is something that's totally outside the buyer's control, then they don't have loan approval. I fight lenders on this all the time because I try to get them to put in writing whether or not the buyer has loan approval, and some of them won't do it. Sometimes when a buyer wants to terminate the contract, I'm looking at a conditional loan approval and I'm asking the lender to say, can you put in writing that the buyer has not yet obtained loan approval? And they say no. So another important reason to be on the same page as your lender. If your buyer is telling you, hey, I know you have your people, I'm sure they're good, but I've been banking with Bank of America for 35 years and they're giving me this great rate, please have them at least talk to somebody. You can't force them to use your lender, but at least have the conversation. Have them talk to me. I can explain to them what a nightmare it is to deal with Bank of America or a big institutional lender that they have no real contact with whoever is actually doing their loan. We can tell them that the people in Bank of America are not even licensed loan originators.
Wow.
You know, that's all stuff that I can help you with. You can't force them to use someone, but I can give them advice as to how a transaction goes.
I can't hear you. I don't know if everybody lost audio.
Hey, sorry, everyone. Okay. I don't know why I got muted there, but what I was saying is that there is no benefit to sending this form over early to the seller. Okay. So some of the questions are, when would we send this over? You want to send it over the last day of the loan approval period or the day before, because there's just no benefit. Let's say you tell the seller within 15 days that you have loan approval, and then the buyer loses their job and they lose loan approval. There's no benefit for you telling them early that you had loan approval. Okay. So the important thing is you need to have this sent in writing. And if you don't, you're putting yourself in jeopardy. Some of your brokers have this form already. They've put it into app files. If your broker hasn't, I can send them over a form that is editable. I can send you the form. I'm going to post this. If Facebook allows me, I'll put it in Word format, so you can have the ability to edit who the buyer's names are and everything. If not, it'll be a PDF on there. It's a pretty simple form. And I've had agents who have gotten this form and submitted it with their offer. Don't do that. this has to do with the loan approval period. Okay. So be conscious of what you're doing. And if you are unsure, then just give us a call. Okay. Does anybody have any questions about this section, loan approval in general, and any of the changes that have happened in the new contract for financing? There's one other thing I want to go back and talk about in the financing section. I dealt with this recently. Line 100. Loan approval, which requires the buyer to sell other real property, shall not be considered loan approval unless Rider V is attached. Rider V is the sale of buyer's property contingency. So what this is saying is if the loan approval says, or it's conditioned on the buyer selling their home, the buyer can't get loan approval under this contract. Just like if the loan approval is conditioned on appraisal. Until the appraisal is in, the buyer can't get loan approval as per the definition of loan approval here. Doesn't mean they can't close, just means they haven't met the terms of the contract for what's defined. But if they have Rider V attached, and that is one of the conditions of their loan approval, they can say, I have loan approval, because they have the contingency to be able to cancel the contract if their property doesn't sell. I can't stress enough that if a buyer needs to sell property in order to get the loan for their new home, you need to have this rider, or you need to have in writing from your buyer specifically telling you it is okay to enter into contract without this contingency. Because when their property doesn't sell and you have no control over whether or not their property is going to actually close, when it doesn't sell, they're going to blame you. So this form and what I was talking about with the Rider V, that's cover your ass, right? Your buyers have short-term memories, and when shit hits the fan, they're going to blame you. So you need to protect yourself, okay? Everything that's out of the ordinary or out of the norm, get them to write in an email to you directing that, okay? Okay. Next section is closing costs. I'm not going to cover this too much. We have an app, jkclosingagent.com. If you go to our main website, if you need the link to the app, I think I put it in the chat. I'll put it in the chat again. But this app will calculate your closing costs. Okay. And we have different counties in there, and you can move title from the seller side to the buyer side. And you can also add in your transaction fees that your brokerages charge. You can add in if a seller has a mortgage payment payoff, you can give a seller net. There's also great social media features in there. So I encourage you to download the app. You do not need to ask us for a prelim CD or a prelim HUD. The app will have the exact same information that we have, because you're giving us all of the information. If you're the listing agent, you will know whether the seller has the mortgage and whether or not they have a payoff for that mortgage. And if you tell us that, all we're going to do is input that. Okay, so check out the app, utilize the app. It's great. And if you have questions about it, you can ask us about it. There are tutorials for it. There's a helpline for it. We also have some webinars that are posted in our Facebook group that are specifically for the app as well. In terms of title and who pays for it, option 9C1, the seller pays for title, meaning they pay for title insurance, the title search, and the municipal lien search. Option 2, the buyer will pay for title insurance, the title search, and the municipal lien search. Option 3, the buyer will pay for the title insurance, but the seller will pay for the title search and the municipal lien search. So this is most common in Miami and Broward. Buyer chooses the closing agent, buyer pays for title insurance, but the seller pays for the title search. And if this line is left blank, then the max that the seller can pay is $200. I have some offers that will come in, especially from brokerages that have their own title companies. I won't name names, but they are out there. They will put like $600 or $700 for a title search here. You cannot allow that if you are a listing agent. Okay, so be mindful of that. Also, this is all negotiable. If you're in Miami, you don't have to choose this section. You can choose this section. If you're in Palm Beach, you don't have to choose this section. The buyer could pay. I've recently been advising buyer's agents, hey, if you're having trouble getting under contract, talk to your buyer about paying for title insurance. That is an easy way to not change a purchase price, but to shift closing costs in favor, of the buyer paying versus the seller, saves the seller money. That might distinguish your offer from someone else's offer. Okay, on a $500,000 property, title insurance is $3,000. So when you're talking about numbers that are that big, the title insurance cost is really not that much. In Port St. Lucie, Martin County, oftentimes it doesn't matter whether the seller or the buyer is paying for title, and that will be negotiated. Agents that work with us up there usually have their buyer or their seller pay for title insurance so that they can control the transaction. Most of the transactions up there are under $400,000. And so the cost for title insurance is not that much. If you have a client who is considering doing this and they're tight on funds, give me a call and we can talk about whether or not there are other fees that they can save on. Okay. But in this competitive market, you want to make sure that you are putting your best foot forward for your buyer. And that's one of the ways to do it. Okay. Similarly, if you have a seller, who wants to control the transaction and make sure it closes, it's a seller's market. You cannot force the buyer from the seller side. You can't force the buyer to use the seller's closing agent or the seller's lender, but you sure as hell can recommend it. And you could say, you know what, your offer stands a much better chance against these 50 other offers I have if you use the people that we're comfortable with. You absolutely can do that. You cannot make the contract state that the buyer is required to use your lender and your closing agent. Okay, but if that's part of what's negotiated, you write in the contract that the buyer and the seller agree, JK Closing Attorneys is the closing agent, so-and-so favorite lender is the lender. And if it's really, really important to the seller, we also can actually say that if it changes, the seller can terminate the contract. Okay. So it's all about negotiating. And in this market, you listing agents have been overwhelmed with offers. You want to make it as easy as possible. Okay. And we've been seeing from the seller side, buyers not be able to close because the offers that they are submitting are unrealistic. And we don't find out about it until the end of the loan approval period, sometimes at closing. Okay. If we're the closing agent on the transaction, we have a much clearer picture as to what's going on with the lender. If we are just doing a seller representation and we have no communication with the lender other than what our phone calls to them are, we really don't know what's going on. So it's something to consider. Special assessments, public body assessments do not include condominium or homeowners associations. So this section has nothing to do with HOAs or condos. Okay. Somebody asked a question. Should we use this contract even for condos? Yes. And you're going to use the condo rider. I have the condo rider in the back of this. We'll talk about it in a little while. This line is pro seller. This line is pro buyer. What does this mean? If there is a public body assessment, such as an assessment for building roads or building sewers or something like that, it is included in the seller's non-ad valorem taxes. You can look up the seller's taxes and figure out whether or not there are special assessments. If there are special assessments, Normally, they are prorated at closing, just like taxes. If this box B is checked, the seller has to pay them in full prior to closing, if that is an option. Many of these do not have that option. Okay. This section down here says that these don't apply to a special benefit tax lien imposed by a community development district or a special assessment imposed by a special district pursuant to Chapter 189. You guys do not want to have to figure out whether or not something is a community development district or a special district. Okay. I always recommend checking A. Especially if you're on the seller side, you should have A checked. But in reality, the buyer is going to be benefiting from whatever special public body assessment is in place, because they're going to be benefiting from the road or the sewer or whatever it is, and it should be calculated in their taxes each year. If that hasn't been contemplated, it should be negotiated. Usually the seller will know if there's some sort of special body, public body assessment. The North Springs Improvement District in Parkland, that used to be affected by this section. Now that special districts pursuant to Chapter 189 don't apply, the North Springs Improvement District does not apply to this section anymore. So you don't have to worry about that. On the app is a white label app. You're going to choose our company. It's not Fidelity or South Florida. There are other title companies that have the same app as us, but only ours has the counties that we have in there and our closing costs. Okay, so just be careful of that on the app. If you're dealing with a condo, what do we do with this section? Nothing. This has nothing to do with condos or special assessment or homeowners assessments. The special assessments are in the condo rider. Okay. I highlighted sections here about FIRPTA. You do not need a separate FIRPTA addendum. It's already written that the buyer and the seller have to deal with FIRPTA in this contract. The FIRPTA addendum that I see that a lot of you have me review has to do with the standard contract. So you do not need a separate addendum for FIRPTA. When you are dealing with a foreign seller, however, you want to make sure, in order to save your seller as much money at closing as possible, that the buyer is going to be willing to sign the FIRPTA affidavit. The FIRPTA affidavit says that the buyer is going to be using the property at least 50% of the time or more for the next 2 years. Okay. It doesn't mean they can't rent. It just means they have to use it more than they rent it. Doesn't mean that they have to live there full time as their full-time residents. All it means is they have to live in it, or their family members have to live in it more than they rent it for the next 2 years. That's the FIRPTA affidavit. If you have a foreign seller, you should be writing that in your MLS, and you should be making sure that the buyer is willing to sign that affidavit. If the purchase price is under $300,000, there does not have to be a withholding. If it's over $300,000, there always has to be a withholding. Lori, to answer your question, our company name should be in the app in that drop-down list. So click on the county that you're in and then look for JK Closing Attorneys. Okay, property inspection and right to cancel. This is the most important section of the contract to the buyer because it allows them to inspect the property and cancel the contract for any reason or no reason at all. Okay. I've underlined the section about permits. Okay. The seller shall not be required to expend or become obligated to expend any money. Okay. So what does that mean? It means if there's a permit issue and it's discovered during the inspection period, because this is in the inspection period section, the seller has to help close it out, but they don't have to spend any money to do it. Because the buyer, if they can't negotiate with the seller on it, can just cancel the contract. The problem with this is that most municipal lien searches do not come back during the inspection period. Almost none of them do. So that's why savvy buyers attorneys and buyers brokers put permit language in the additional terms. Okay. Sometimes we see language like seller at seller's expense shall close out any and all open or expired permits and liens prior to closing. That is not good for the seller, because the seller may not know whether or not they have open or expired permits. They may not know whether or not they have code violations and municipal liens. If they have a renter in the property, the renter could be getting all sorts of notices about code violations and not giving them to the landlord. If you are a listing agent and you allow this language to be in the contract, you are opening your seller up to a liability that you have no idea how much it could be. It could be tens of thousands of dollars that they have to pay. And if this language is in here, it means they have to take care of it prior to closing. And if they don't, then the seller is going to be in default, which means that the buyer can end up suing them. So if you are a listing agent and you are faced with this language, we like to have this language replace it. It's neutral. It says, if we discover any of these items, the seller can close them out prior to closing. If they elect not to do so, then the buyer can either accept the property or cancel the contract. Normally, what we end up doing is negotiating for the seller to put money in escrow to allow for time to be able to close out these permits or code violations. With code violations, there could be funds, dollar amounts that are accruing per day. You cannot close with an open code violation that is accruing hundreds of dollars a day. You have to fix the problem first, get code enforcement to find that the violation has been cured, which will stop the clock on the funds accruing. And then the seller may want to go to a magistrate hearing to reduce the fine. That can all be done, but we need to work together to get it done. Okay, this language protects the seller and it protects the buyer. That's why it's neutral. If you are representing the buyer, you need to put something in this section, whether it's the neutral language or buyer-friendly language. This is the preferred buyer-friendly language. Some of your brokers have language that's longer than this, and all the ones that I review are fine. But you need to put something in, because the contract assumes that you're dealing with this stuff during the inspection period. Okay. Let's see. Does anybody have any questions about the inspection period in general or permits? When you ask me to review a contract, either from the buyer or the seller side, one of the things I'm looking for is permit language. And even if you have the perfect offer, I'm still going to suggest that you change the permit language. If you don't, or you just want to get it signed, then your seller needs to be made aware of the risk that they're taking by doing that. We can run a build facts report, which will show whether or not they have open or expired permits. It's not 100%, and it will not show code violations. So we need to be careful of that. Again, we want to protect our sellers and our buyers. Okay, I'm going to skip over this page for now. And addendums. I mentioned before that we have preferred appraisal language and post-occupancy language. This is that language. Okay. With appraisal language, I do not want to see in your contracts, buyer is willing to pay X amount of dollars over appraised value. That is the number one language that gets everybody into disputes right now, because it doesn't say what the seller has to do. It doesn't say whether they have to reduce the purchase price. It doesn't say whether or not the buyer can cancel the contract. You need to be very, very clear with your appraisal language. If you are afraid that the seller is not going to accept your offer with appraisal language in there, this is where you guys need to step up and use your negotiating skills from the buyer side. Explain to your seller, the listing agent, why your offer with an appraisal contingency is so much better than the other ones. Number one, your team is better. You have a lender that's going to be able to get it done. Maybe your buyer is willing to pay above appraised value. That's great. but you need to be able to say what happens if it comes in lower than that dollar amount. If they're willing to pay $20,000 above the appraised value and the appraisal comes in 30,000 short, what happens? You need to say that they're going to be able to terminate the contract. This paragraph right here is a normal appraisal contingency, except it says if the parties are unable to reach an agreement within 3 days of receiving the appraisal, either party may terminate the agreement. I've found more success with this language in getting sellers to accept it because it makes the seller psychologically feel like they have options. Oh, if the appraisal comes in low, I don't need to move forward with it. Okay. You guys need to get under contract and you need to get your offers submitted. So anything that you can do to get an edge to be able to get your offer submitted is helpful. And sometimes that is just playing, into what the seller is really looking for. Most sellers know, and most listing agents know, correct me if I'm wrong, but they know if something is going to come in low for appraisal. So at a certain point, they're just trying to figure out how much will the buyer be able to pay above appraised value. If you are competing with cash offers and your buyer is financing, don't forget that your buyer has much more purchasing power than a cash offer might. Now, if you have a cash offer at $900,000 and you have a financing offer at $900,000, the seller is probably going to take the cash offer. Okay. But what if the buyer was able to raise that up to $950,000? How much more would that cost them per month on their loan? How much more would that cost them down? Depending on how much they were going to put down, if it's less than a 20% loan, not that much more. Even if it was a 20% loan, it'd only be $10,000 more down on a $950,000 home. If it didn't appraise, that's where we would want to have the appraisal language, or we don't want to just rely on the loan approval period. And we don't want to rely on the loan approval period because you don't know whether or not the lender's loan approval is going to be conditioned on appraisal. So I've had lenders recommend that in order to get a buyer's offer taken, that they put more money down. Okay, make it a 70% loan. You'll get your offer accepted. Yes, you will. But if that property appraises low, they may not be able to terminate the contract due to failing to obtain loan approval, because they may still qualify for the loan if it appraises low. I've had that happen before. I'm actually in a dispute representing a seller because the buyers came back on a $900 and something thousand loan. It was 70% loan to value on the offer, and the appraisal came in 40,000 short. It changed their loan to value to 73%. They said they were terminating the contract because they didn't get loan approval. I called BS on it. We had a chatty lender and we had a chatty attorney on the buyer side. They sent us over everything. They sent over the loan conditions. The lender put in writing that nobody said that the buyer didn't have loan approval. We had a lot of information on that. It turns out from the loan conditions that appraisal was not even a condition of the loan. So for them to say that they were terminating the contract because they didn't get loan approval due to the appraisal was just a lie. So now that seller is going after that buyer's $50,000 deposit. If they had an appraisal contingency in there, that would protect them, regardless of whether or not they have loan approval. Okay. Post-occupancy language. Again, I said I don't like Rider U. This is a list of stuff that you can put in an addendum or additional terms for post-occupancy. Okay, we're going to agree to a post-occupancy agreement. Here's the termination date. The rent is this. The security deposit is this. If the seller stays past the termination date, it's X amount of dollars per day. All the other terms are going to be agreed upon prior to closing. Okay. Again, I'm going to post these in the Facebook group, and then if anybody wants them to me, I will email them to you. These are other example languages, language that we use for addendums, especially from the seller side. Okay. If you are representing the seller and the buyer cannot close on time. They need an extension to the closing date, or they need an extension for the loan approval period. They are telling you that there's a problem. Okay. Every day that the seller doesn't close or has their house off the market, they're losing money. They have carrying costs. They're missing out on other offers. So for the buyer to come in and say, I need an extension to my loan approval period, or I need an extension to the closing date, that's costing the seller money. Okay. So if the buyer does come to us with asking for an extension, we need to contemplate whether or not that's in the seller's best interest. There's a big difference between asking for an extension for a day or two and asking for an extension for a week or 2 weeks. And it depends on what the seller's appetite is to give that buyer an extension. We always ask for prorations, meaning we want all the prorations to be as of the original closing date, because the further we go and the further the closing date goes out, the seller's taxes, their condo fees, all of the things that are prorated cost them more money. So we want to lock those in. We might ask for an additional deposit. We might ask for the buyer to transfer the deposit to the seller. Okay, why would we do that? Why would the buyer do that? Well, if the buyer can't close on time and they're past all their contingencies and they don't close, they're going to be in default, which means that the deposit is supposed to go to the seller. If they extend the contract out for a week and they don't close, then they're in default and the deposit is supposed to go to the seller. There's no scenario in which the deposit is not supposed to go to the seller. If they close, the deposit is part of their closing costs and goes to the seller. So when we ask for the buyer to transfer their deposit to the seller in exchange for an extension, and the buyer says no, that tells me that the buyer's not confident they're able to close. And right then and there, we should stop and move on and find a new buyer. Because eventually your seller is going to be mad at you, listing agent, if you keep extending the closing date. Okay, don't go, it's the sunken cost fallacy. If the buyer can't close, you guys aren't getting paid. The seller's not getting paid. Don't keep extending the contract for them. Make them put their money where their mouth is. If the buyer asks to extend their loan approval period, don't just let them extend it. Consider what they need to get done. Ask the lender for the conditions of the loan approval. Maybe we put in a kickout clause in exchange for an extension of the loan approval period. Okay, contact us. We can help you figure that stuff out. Okay. Okay, couple questions. Regarding post-occupancy, if the seller ends up finding a new home before closing their existing home, do they still have to pay the buyer the monthly rent in the agreement? Depends on what you agree to in the post-occupancy agreement. So many post-occupancy agreements state that if they leave early, they will get credited back the money. Some of them do not. Depends on what's negotiated. So that's something that needs to be written into the post-occupancy agreement. And if you are thinking about it while you're getting into contract, then you should put that in the post-occupancy additional terms too. Condo Rider. I'm going to cover a couple of things on here. Special assessments and prorations. Remember I said section 9F of the contract has nothing to do with condos or associations. This is where we deal with special assessments for condos. Page 1. These fees, assessments, prorations, and litigation are not special assessments. They are the regular assessments. Current rent on recreation areas go here. So if there's a rec lease, you can put a special assessment here. It won't hurt you, but this is not the special assessment section. If there is a special assessment, it needs to be disclosed on these 3 blank lines here. So if a special assessment exists, you need to write it here. If you don't write it here, then the seller has not disclosed it to the buyer per the terms of this contract. So any special assessment that exists or is pending needs to be written here. Then part 2 here with the boxes for buyer and seller applies to whatever is written here. So if you have a special assessment and part of it is due prior to closing and part of it is due after closing, and it's written here, and you check buyer, then the buyer will pay for what's due after closing. If you check seller, then the seller has to pay it in full prior to closing. If there is nothing written here, it does not matter what you put here, because this only applies to special assessments levied or pending that exist as of the effective date and are disclosed above. If you don't disclose anything, then there's nothing for the buyer or seller to pay before or after closing because it's not disclosed. If a special assessment exists as of the effective date and has not been disclosed, then the seller is responsible for paying for it at full or in full at closing. Okay, so rule of thumb, if it is not disclosed, the seller has to pay for it. If it is disclosed, then these boxes control. There are some special assessments that condos will pass that say upon transfer of the unit, the special assessment needs to be paid in full. That means that the seller is responsible for paying that special assessment. Okay, so if a special assessment exists, you should read it. If you don't understand what it says, have me read it. If I don't understand what it says, we'll go back to the association and ask them what it means. Okay. If after the effective date, the association imposes a special assessment for improvements, work, or services, which was not pending as of the effective date, then the seller pays the amounts due before closing and the buyer pays the amount due after closing. If it is a building that you know is going to have a special assessment, but nothing has been written in the minutes, they haven't discussed it yet. From the buyer side, you may want to modify this section, because if you're negotiating that with the seller, you either want to get a credit, or if you don't know how much it's going to be, you may want the opportunity to renegotiate during the course of the transaction. How would you know about this? A board member might be saying, hey, we've got a lot of work to do. We're going to have a special assessment. If it is not in the agenda or reported in the minutes within the last 12 months, then it is not pending and it is not assessed. So it is, if it is just hearsay, then it doesn't exist. It may never exist. They may never be able to get the support from the community to pass the special assessment. That's why the contract is written the way that it is. Okay. Does anybody have any questions about condo special assessments? Someone's asking, is this the most recent version? It looks different than the one in app files. No, I don't think it is the most recent version. This is the one that I edited. They're very, very similar. This section's not really changed.
Hi, CJ.
Yes.
I have a question because the timing is a little bit confusing here because the buyer typically is proposing this disclosure. And if nothing's been put in the MLS or otherwise disclosed, a buyer's not going to know.
Yes. Right. And so it's going to be blank, which means that the seller would have to fill this in if there are special assessments. If it's blank, that's favorable to the buyer because it means that the seller is going to have to be responsible for anything that's not disclosed.
Then should we check seller even if we don't know as the buyer's agent?
If there's nothing written here, and you check, I mean, from the buyer side, it doesn't hurt to check seller. If the seller goes back and writes in a special assessment here, and you have the seller box checked, they would have to switch it to buyer in order to change it. So yeah, it does not hurt to check seller from the buyer side. If you are a listing agent, it would be great for you to fill out the condo rider and include it in the MLS. That way, the offer that the buyer is sending will be pre-filled in and you don't have to do that extra work of filling it in. Okay. Next part of the condo rider. Documents. 5B says this agreement is voidable by the buyer by delivering written notice of the buyer's intention to cancel within 3 days, excluding Saturday, Sundays, and national legal holidays, after the date of the execution of this agreement. This means that once this condo rider is given to the buyer, they have 3 days to void the contract, regardless. So if you have a 0 inspection period offer and it's a condo, the buyer has 3 days to void the contract. It also says, and receipt by buyer of a current copy of the declaration of condominium, articles of incorporation, bylaws and rules for the association, and a copy of the most recent year-end financial information and frequently asked questions and answers document, if so requested in writing. And in section 6 is where the buyer requests it in writing. So what does that mean? Until the buyer is given these documents, they are able to void the agreement. Or once they are given these documents, they have 3 days to void the agreement, presumably so they can review the documents. Most associations do not have a frequently asked questions and answers document. If you are a listing agent, you need to get that document. I have a form that you can give to the association for them to fill out. Why is it important for the frequently asked questions and answers document to be given? I will show you in a couple minutes. Why is this important? Buyer's right to void this agreement shall terminate at closing. If any of these documents are not given to the buyer can go all the way up to closing and void the contract. All they need to do is say, I requested all of these documents in writing and you did not give them to me, so I am voiding the contract. I've gotten buyers out of contracts that way. Buyers' attorneys have argued with me and gotten their buyers out of contracts that way. This is a statutory requirement in Florida. It cannot be waived, and the association must have these documents. So if they don't have a frequently asked questions and answers document, and these are the types of questions that are on there, you can click this link and it will bring you to a fillable form that you can give to the association property manager to fill out. And that's it. And you can give it to the buyer. Again, like I said with the condo rider, if you could put all of these documents in your MLS listing, then it's there and you don't have to give it to everybody again. The frequently asked questions and answers document must be updated every year. So if you have the 2021 version of it, that is not sufficient. You have to give a updated 2022 version. One of the questions on that document is whether the association is currently engaged in litigation. They could not have been sued last year, and this year they're being sued. That's why it needs to be updated. Okay. Questions from people. What if the documents are on a website? If the documents are on a website, the listing agent has to send the buyer the website so that they can download them. I have had associations that claim all of their documents are on the website, and then they are not all on the website. So from the listing side, you got to be careful of that. The frequently asked questions and answers document is only for condos. It is not for HOAs. Okay. There's a question about board members who are not giving the information that you need. There's 6 board members. They all do whatever the heck they want. We all deal with associations like that. Okay. The best thing that we can do is get the association attorney's contact information. If we can do that, great. If we can't, the seller is the one with the right to go after the association for not following their own rules. Okay, so we have a buyer who's denied by the association unfairly, or the association is just not approving them, and we have no answers. The seller is the one who has to go after the association. So demand letters, threats, to sue them for not turning over the information. That is stuff that we can do with board members, but a lot of these people are volunteers who don't really know what they're doing. And we have to try to get them to cooperate. The only thing in that can get them to actually comply is usually badgering them a lot, meeting them, continually asking them in person, going to the property manager, standing there and waiting. Unfortunately, this is the type of stuff that you have to do with associations sometimes. It's unfortunate, but if you have difficult associations, it's really the seller's responsibility to try to go after them. If there is litigation disclosed, must the association reveal the extent of it? To the seller, they should, yes. They are not obligated to the buyer, but then that might mean that the buyer is not going to close. It might mean that the lender can't close. Usually there's an opinion letter that needs to be drafted by the association attorney that outlines the extent of the litigation that can be given over to the attorney to satisfy them. So that can be a tricky situation. Again, with associations, the seller is a member of the association, and if their closing is being prevented by the association, then they have a claim against the association. And that's normally the avenue that we have to pursue. Okay, another question. What if the agent advises for you to, hang on one second, for you to leave those documents in the unit via text and email you to advise them that the documents are there ready for pickup within 3 days from the effective date? If they don't pick them up, what happens? You have to actually give them to the buyer's agent. So if they don't go pick them up, it means that they never got them. If you have a lot of documents and you guys need to scan and email them, feel free to drop them off at our office. We'll scan them and email them for you if you guys don't have scanners. Okay. Any other questions on condos? I'm going to skip over FIRPTA. I mentioned that we can do an entire training for FIRPTA for an hour. There's a great company called FIRPTA Solutions that can explain everything. Normally what I do is put you guys in touch with FIRPTA Solutions if you have a seller that has to deal with FIRPTA. Same thing, 1031 exchanges. We have a great company, Midland 1031, that's a qualified intermediary. I will put you in touch with Janet from there if we need to do a 1031 exchange. I want to cover briefly contract to lease. Contract to lease is one of those documents that I do not like. You do not need a contract to lease. If a tenant is willing to lease a property and a landlord is willing to lease it, just fill out a lease and get everybody to sign it. If the landlord is requiring a contract to lease, you need to be careful from the tenant side as to what you put in section 2 here. Okay, section 2 is the deposit. It says you have put the deposit in with the deposit holder, which might be us, might be your brokerage. And then in section 16, it says if the tenant fails to perform, then the deposit will be retained by the landlord. Tenant failing to perform would be like if the tenant doesn't agree to execute the lease. So if they have a $2,000 deposit here, they're going to lose that deposit. So generally I put to be paid upon execution of lease or something like that here if a contract to lease is required. And then you can outline when all of the deposits are due in this section over here. But the reality is I don't really like contracts to lease. They're not really required. If your tenant's willing to sign a lease, have them sign a lease. Okay, you guys want to get your commission. The landlord wants to get paid. We don't want to get into disputes over a contract to lease, which is basically like a binding letter of intent. Seller net sheets, we have this, but again, you can use the app. We do seller representation in Broward and Miami. We do buyer representation in Palm Beach. If the buyer is paying for title in Palm Beach County and you have the listing, you can have us do a seller representation. Just treat it like it's a Broward or Miami deal. No big deal. Again, the app, I've mentioned that before. It's a really useful tool.